honestly, this should have been handled before trial. Because the only way for me to really know is if I watch the whole video. And I'm not going to, in the middle of trial, take a time out and watch an over an hour long video of the defendant's interrogation. So I'm flying blind here, relatively speaking. So there's no way for me to know if, in fact, the statements that the detective made are, in fact, relevant to any potential impeachment or issue. And I just want to clarify, make sure for the record, Mr. McLymont, you're not claiming that these statements made by Detective Ramos go to the voluntariness of your client's statement, or are you?
Not that the statements are involuntary, but they invoke certain responses from Ms. Andrews. It's not that.
Okay, I just want to make sure we're not talking about voluntariness. We're simply discussing context, correct?
Correct.
Okay, and so then that's where the rule of completeness comes in.
So, Judge, if I can,
Yep.
First of all, yesterday my statements on the record were incorrect about the law. This law has been in flux for 2 decades now, and my reading of it last year, my memory of it was skewed, so I apologize for that. But basically, the rule of completeness is not absolute. The correct standard is whether, in the interest of fairness, the remaining portion should have been contemporaneously provided to the jury. I think the closest case in the group that I sent to the court is going to be the Dissett case, which is a 4th DCA case in 2007, in which the 4th DCA found there was no violation of the rule, where the trial court excluded irrelevant portions of his statement. The state's edited version of the tape did not create misleading impressions or take statements out of context. Additionally, it reads the state's edited version did not exclude exculpatory statements. In fact, part of what the state excluded was the defendant's admission that he had used robbery money to buy drugs, a collateral bad act. Similarly, in this case, Your Honor, the majority of what we're attempting to exclude are not the defendant's statements, but the detective's statements to her about completely irrelevant matters that are not only irrelevant to this proceeding, but would be misleading and confusing to the jury. Specifically, he is telling her, you are going to receive a life sentence if you don't tell us what happened, if you don't give us your version, if you were dragged into this gangland war by Mr. Chance or others, you need to tell us now. You're looking at life. And he doesn't just tell her you're looking at life. He fleshes it out in long narratives where he talks about the implications of life. Her life in the prison, that it's going to be her nursing home, that she's going to be woke up every morning and told what to do, what to eat, where to go. He talks to her about the fact that she'll be walked out to a yard where it's surrounded by high walls. Then he proceeds to tell her all of the things that she will miss. She'll miss Thanksgiving dinner with her parents. She'll miss all the things that other people have in their lives, while the co-defendants may be out running around living the high life. His statements about the life sentence, number one, not only is that irrelevant, it's misleading to the jury and confusing to them because it's not something for their consideration. In fact, as the court's well aware in your instructions to them, you're going to tell them they cannot consider any potential sentence. And also, as the court's aware, normally jurors never know what the potential sentence is in a case like this. Excuse me, counsel, I would like to finish my argument.
Okay, please step out, Detective.
So the court has suggested a curative instruction. So basically what we would be doing is putting before the jury something that they shouldn't be hearing and then trying to cure it with a curative instruction instead of just excluding it. What her potential sentence is and what the ramifications of that potential sentence are irrelevant to these proceedings. Counsel said they put into context the defendant's statements. There are no statements by the defendant. That's what this is all about. She is not telling the detectives the truth. They also keep asking her to tell them the truth and telling her if the jury is potentially going to give you any benefit or any kind of mercy, you need to tell us the truth or they're going to see this. they're going to see what you didn't tell us. They're going to see all these things that you didn't say to us. And there's silence from her. She continues to deny or absolute silence. So it's not really putting any of this into context.
Well, then why is if she doesn't say anything inculpatory after the detective tells her these things, why is that even coming in?
I don't believe it should come in. She does make statements, and they are obvious lies, and I think that's relevant.
Is that before the Detective Ramos makes those representations?
Yes. I think the majority of her statements are made before he starts encouraging her to tell them what happened, to tell them the truth. I'd have to defer to Ms. Doherty. I don't know the statement as well as she does, but are there statements that, does she continue to lie after that?
Judge, there are denials throughout, but I had originally proposed ending it a little bit earlier when she first says that she is done, which puts it, almost chops it in half, but there were still statements prior to that, but I think defense counsel wanted it all in until the very last point where she says she wants an attorney.
But this is what I don't understand. So that only comes in, because those are all hearsay statements by the detective, okay? So anything that she says after that, what is the relevance and why is it admissible? Because if she's not making admissions, then it's hearsay. Anything she's saying is hearsay. I'm failing to see why, if she doesn't say anything that the state's intending to introduce after the detective makes those representations to her, then why are we showing it at all to the jury?
Well, prior to him doing that, she makes several statements that are inculpatory.
Okay, well that's different.
And she makes denials in situations where a person, the state would suggest to the jury that it's innocent, would not make, and obviously are inculpatory because they're false, and obviously false, and to be proven false.
So she does make statements to the detective after he tells her all these things about prison and her sentence. Is that what you're telling me?
I'd have to ask Ms. Doherty. I reviewed more of the redactions than I did her responses once that started.
Well, she, like I said, she denies certain facts after that.
I know, but that in and of itself, honestly, that's hearsay, honestly. Only admissions or statements against interest come in a interview.
Well, it is against her interest if they're going to get on the stand, put Ramos on the stand and say, at this point she's lying, right? And they're going to present to the jury that she lied about X, Y, Z things throughout the interview. So that all of those statements are against her interest.
Okay, but again, let's just remove anything that happens before Detective Ramos makes those statements to her about the potential sentence or what's going to happen to her. That's different. Okay, we're only talking about anything she may have said because that's the only context that would be part of this discussion. I mean, it seems to me the easiest thing to do is just nothing that Detective Ramos says or anything she says afterwards comes in. It'd be the easiest way.
So that would be cutting the interview short, Judge.
So what? That happens all the time.
Right, but you're cutting the interview, you're showing half the jury, half the interview.
I know, but the rule of completeness is only necessary to bring in any other statements if it needs to give context to something. If the original statement from Ramos regarding the sentence and how life in prison is going to be, if the jury never hears that, then they don't need to hear the context of her responses. They don't need to hear it. So, because that's the only reason that the rule of completeness would be applicable here.
Well, Judge, so what you're saying is that the statements up front, the ones before they start to threaten and they start to tell these different things, that those statements, and they're all interwoven, so it's not like it's just a clean break, as though at one point in time they made these statements and she's already said everything she needs to say that the state wants to introduce. It's interwoven. There's some time that goes by, they start to threaten, they start to talk about the different punishments, more interviews. More statements from the detectives, more interviews. So it's hard to just cut it off at one particular point. Like you said, if this was an issue that the state saw, this is a motion that the state should have filed prior to the trial. We filed our motion to suppress last year, December, on this issue. And I was under the understanding that at 1:22, that's when the interrogation cuts off, because that is when she invokes. So outside of that, like right now, without actually going through line by line, minute by minute, and not being able to tell you, this is when they say this is when she says that, it is just piecemeal. And if the state wants it out, they should have done it beforehand. Not like right in the middle of the trial, right before the detective gets on the stand, in the middle of his testimony.
I have been, since the first trial, discussing potential redactions with them and have gotten no response. I have brought this up, no, I can show emails where I have brought it up multiple times before the first trial, and then I readdressed it before this trial where I proposed and went line by line and sent them a highlighted version of what I believe should come out, including stopping it early. So I definitely have been waiting for their response and their communication. It has included coming into this trial where I, again, asked a couple of times that we needed to address this, or we'd have to bring it in front of the judge.
Well, then you should have brought it before the judge. If you weren't getting anywhere, you should have filed a motion in limine to address this. Because again, there's no way for me to know until I sit down and watch that video. There's no way for me to know the context. I have no way of knowing. And I'm not going to do it in the middle of trial. I'm not. So I really don't know what else I can tell you all. It doesn't seem to me, and I'll repeat this, if there's no admissible evidence, meaning inculpatory statements that she makes after, or anything you're going to use against her, after Detective Ramos makes his statements to her, I don't think any of that should come in at all. At all. It's not relevant.
Well, just in a review of it, apparently there is some things that she does say after he starts.
That you wish to use?
Yes.
Against
that,
her?
Yes, that we would suggest her very incriminating.
Okay. So then at this point, I'm inclined just to give a limited instruction. Just remind the jury that anything Detective Ramos says, his opinions are just that. They're not necessary. They're not true. They're not to take it as true. So at this point, I don't know what else to do other than that. Okay? And just while we're talking about it, assuming that it comes in, I give the limiting instruction. I don't want anybody getting up in front of this jury and in cross-examination or closing argument or direct or whatever it may be, and ask a witness or have the defendant testify, and are you in fact facing life in prison? No one's going to ask that question or testify to that. The only reason this is coming in is to purportedly show the context of Ms. Andrews' responses, and that's the only way it's going to be argued in front of the jury.
And just to be clear, I do not intend to ask Detective Ramos a question that would give the jury the impression that what he's saying or what Detective Campbell is saying is true, that she's actually going to face life in prison.
Okay.
Right? But the statements that he makes, not just the life in prison, but some of these other statements, I should have the ability to cross-examine him on the effect that that would have had on Ms. Andrews at the time.
Well, he can't testify to what's in her state of mind. You can question him about what he said to her, but he can't guess what effect that had on her.
So, and it's not just the effect it had on her. It also goes to our ability to cross, the wide latitude that we do have to cross on motive, bias, and credibility of any witness, especially of the detective in this case.
Well, we'll just have to play it question by question, okay?